All right, and welcome back to the Pearl Snap Tactical Podcast, the show that gives you tips and information on how to make yourself stronger, faster, and harder to kill. Recorded live from an undisclosed location south of the Mason-Dixon line. Welcome. I'm your host, Mark, and joining with me is Andrew Branca, Esquire. He runs a show called The Law of Self-Defense. He's an author, a lawyer. He specializes in, as you can guess it, laws regarding the use of self-defense. So I thought no better person to have on the show to talk about those things than Andrew himself. Andrew, welcome to the show.
Oh, thank you very much. I appreciate the invitation. It's great to be here.
Yeah, I'm a huge fan. I listen to your show myself. I've shared your information on this podcast before, so I'm sure if people are diligent and listening, I've oftentimes included links to your book for people to purchase because I highly recommend it. I think it's very written in a way. The law can be pretty dense for folks sometimes, but I think you write it in a way that's very conversational and accessible and easy to grasp. And some of these things can be, hard to kind of work through. So kudos to you. As we get started, can you just give us a brief background and kind of introduction on who you are and what you do?
Sure. So I'm a lawyer. I really do criminal defense work, but I focus exclusively on use of force law. So I don't do DWIs and stuff like that. I don't have a generalized criminal defense practice. It's defense of yourself, defense of other people, defense of property. And that's been our focus for 35 years now. So I've been doing this quite a bit, wrote a number of books on it, do a lot of legal consulting to other attorneys who are representing clients in use of force cases. A lot of speaking, talk at I teach occasionally at the FBI Academy down in Quantico and various other law schools and forums and places like that. But use of force law is what we do, and it's all we do.
It's kind of funny. I mean, we're kind of living in a society where it does seem like a lot of the established entities, organizations, and everything aren't very 2A friendly. You're obviously very much a proponent and supporter of Second Amendment rights and people being armed, albeit with the caveat that they're trained and skilled and all that stuff that goes with it. But speaking to these groups and everything, have you found that to be a problem or an issue for you?
Well, I mean, not everyone's comfortable with guns, right? To some people, a sizable percentage of Americans, they see a gun and it looks like a rattlesnake to them. And so it can be a little awkward sometimes with those people. They want to know how to defend themselves in some other manner. But of course, I mean, firearms are the most effective means of defending yourself from a violent attack. I consider myself a Second Amendment absolutist. As far as I'm concerned, every gun law preemptively applied to law-abiding, mentally sound American citizens is facially unconstitutional. That's it. Very simple. Shall not be infringed. To me, it's not a complicated legal argument. And people do need to be safe with guns if they're going to have them. You don't want someone getting a gun only to hurt themselves or have somebody in their family be hurt unintentionally. Once they've done that, a lot of defensive encounters are solved simply by having the gun. I mean, most defensive encounters, when a gun is displayed in defense, there are no shots fired. No one's injured. So the first rule of a gunfight really has to be have the gun and have it accessible. And if people can do that in a safe way, I think they make themselves and their families, as you just said, a lot harder to kill.
Yeah. So that leads us to the next question I have. So you're like, hey, first rule of a gunfight is have a gun. But now people, by brandishing it prematurely or, under inappropriate circumstances, can really get themselves, create a bad situation to have it go from bad to worse. So, we have what we discuss, in legal parlance, the 5 elements of self-defense. There's at least 5. Could you kind of walk us through those? Because they're very easy to look at. Anyone can read them on their face, but to really understand how they apply, that's kind of a different story, don't you think?
Yeah, I'm happy to do that. And I should make clear, too, I'm not a fan of defensive display of a gun to intimidate someone. I carry a gun every day. I have my entire adult life for personal protection. I don't anticipate my gun is ever going to come out of the holster unless I believe the conditions have been met to discharge that firearm. Now, when the gun comes out, the situation might change, and it may not be necessary to discharge the gun, and then I won't do that. People shouldn't be shooting people they don't need to be shooting. But you should not expect that just because the guns come out, it means the fight's going to stop. That's not within
Mm,
your control. That's within the other party's control. You can
mm,
hope for the best, but if you're going to present a gun, it ought to be because you believe it's necessary for that gun to be used in self-defense.
mm,
And if it's not meeting the appropriate legal conditions, you are in a lot of trouble. A lot of the cases I work are aggravated assault with a deadly weapon case. No shots are fired, nobody's hurt, but if you put someone in imminent fear of deadly force harm because you've presented a gun, of course you're thinking I did that in self-defense. But if you don't meet the technical conditions of self-defense, you've just committed felony aggravated assault with a deadly weapon. It's good for 10 years in most states. And in many states, there's a gun sentencing enhancement on top of the criminal charge if you do this with a gun, which most of us would be doing. So it's not uncommon for people who've never been in trouble with the law a day in their lives before, thinking I displayed my gun in lawful self-defense, to suddenly discover they're looking at a felony good for 10 to 20 years in prison. So it's really important that people do understand those.
I'm sorry,
Sure,
I
go
didn't
ahead.
mean to interrupt. If I could riff off of what you just said, I mean, I think that's so important. You iterate this in every show because it's what you do. But I always encourage people, like, obviously they're coming to our classes and training with other people, and mastery of the tool is one thing. But I think part and parcel, you can't really be out there training. But I think there's other two components that are just as necessary. The medical aspect, right? We always say if you're going to take a life, you better be able to save one as well. But then understanding the elements of self-defense, the use of force, right? That is part and parcel of it, right? Because the fight isn't just over when the gun smoke clears, so to say. There's this whole legal machine, process that's going to begin through the investigation and everything. And, the law enforcement, whether it's the prosecutor, the detectives, or the patrol officer, whoever arrives on the scene, is going to start analyzing and gathering information and evidence, and it's going to be evaluated. You correct me if I'm wrong. Against these 5 elements in most jurisdictions. What are those elements?
So any claim of self-defense is based on a foundation of 5 legal requirements, what I call the 5 elements of self-defense. The good news is there's only 5. There's no 500, there's not 50 of them, there's only 5, and there's only up to 5. So it's very common for one or more of these elements to be legally waived and not to be required to justify use of force. But it could be all 5 that are required, and those are innocence, imminence, proportionality, avoidance, and reasonableness. By the way, we give away a cheat sheet on these that people can get for free at lawofselfdefense.com/elements. It's just a PDF download. It doesn't cost a penny. So if people are trying to scribble notes right now, you can just get this at lawofselfdefense.com/elements for the 5 elements of self-defense. And essentially, they just mean that for your use of force to have been lawful, you need to have been the innocent victim of unlawful aggression. You can't have been the person who started the fight, for example. That's innocence. Imminence is the threat you're defending yourself against is either actually occurring, you're actually getting beat or whatever, or it's immediately about to occur. The guy's fist is drawn back. You don't have to be struck before you can defend yourself. You don't have to suffer a scratch before you can defend yourself. But you can't be defending yourself against a threat that's in the past, something that happened previously. And it can't be a threat that's speculative and in the future that may never happen. The third element is proportionality, and that has to do with the intensity of the force involved, because the amount of force you can use in self-defense is determined by the amount of force you're threatened with. You can only use deadly defensive force if you're facing a deadly force threat. If you're not facing a deadly force threat, you can only use non-deadly force in self-defense. That's the proportionality, deadly to deadly, non-deadly to non-deadly. Next, we have the element of avoidance, which is the most commonly waived of these 5 elements. So avoidance has to do with whether or not you have a legal duty to retreat before you can use force in self-defense. We've all heard about stand your ground states like Florida, for example. In fact, most states are stand your ground states. Most states, 39 out of 50 states, are stand your ground states. There is no generalized legal duty to retreat before you can defend yourself. But 11 states are duty to retreat states. And in those states, if you had a safe avenue of retreat and you didn't take it, you lose that element of avoidance, you lose self-defense. And then the last element is reasonableness, which is really twofold. So first, there's a subjective component. You have to have a genuine good faith belief in the need to act in self-defense, as you did. And of course, we don't have mind-reading machines. So basically, we infer that from your conduct or things that you say. And then secondly, that subjective belief, however genuine it is, has to be objectively reasonable, meaning a reasonable and prudent person in those circumstances would have shared that subjective belief. The belief can't be irrational or speculative or imaginative, for example. So of the five elements that are required, unless again one or more is legally waived, they must all be present. They are cumulative. They're like chains, links in a chain. If one is missing, you don't have lawful self-defense.
So, it's been a minute since I've been practicing. So just going by memory, I mean, everybody's familiar with the phrase innocent till proven guilty. So that is that the state has to bring the charges. They have to prove every element. The onus is on the state. The defendant, meaning the person who if you find yourself in that position, where you're being prosecuted, you technically don't have to do anything, don't have to take the stand. You have a right not to take the stand and say anything or really mount a defense. It's maybe not unwise. It's not wise to do that, but necessarily in all cases, but technically the state has to do it. But when it comes to defense, if I remember correctly, that is called the self-defense is an affirmative defense, right? Can you explain the difference? Like what is a affirmative defense and how does that play into your presumption of innocence?
Well, so you have to raise the legal defense of self-defense. Let's think about this from a common sense, practical perspective. You've been attacked by somebody. Some guy jumped out of a doorway with a machete and tries to take your head off, and you draw your pistol and you solve that problem by shooting that person. And then you call 911 and the police show up. What are they looking at? They're looking at a guy who's been shot by you, right? That's going to be probable cause for some use of force criminal charge that you now need to justify as lawful self-defense. So self-defense as a legal defense is often referred to as a defense of confession and avoidance, because what you're not saying in a self-defense case is you're not saying, it wasn't me, I didn't shoot that guy. You're saying the opposite of that. You're saying it was me, I shot him, but I did it with the legal defense of self-defense. So if you actually sit silent, well, then self-defense never enters the conversation. And of that confession and avoidance, the only part that a jury would hear would be the confession part. Not that you're confessing to a crime per se, but you're confessing to the underlying physical conduct that is the basis for the criminal charge against you. So you're compelled to make the self-defense argument if you don't simply want to be found guilty of whatever the criminal charge is. And of course, the prosecutor knows this. So it's different than a typical prosecution. In a typical prosecution, the prosecutor's thinking about his burden to prove each and every element of the criminal charge beyond a reasonable doubt. But in a self-defense case, you largely give him that because you're not denying you were the guy who shot this dude. Now the prosecutor knows that what he has to do is not so much prove the underlying conduct, which you've conceded, but overcome your legal justification of self-defense, which means he's looking at those 5 elements of self-defense. When he gets that investigative report from the detectives, what he's looking for is any one of those elements that he feels he can disprove beyond a reasonable doubt. Because if he can disprove any one of them beyond a reasonable doubt, it doesn't just diminish your claim of self-defense. Your self-defense justification collapses. It goes away. And then all that's left of confession and avoidance, again, is the confession part. And that's a pretty easy conviction.
That's a good point. So in your experience, I mean, again, we went through the elements and that could have been a podcast episode just in and of itself, but I highly, recommend your book and even that PDF download you've referenced. I'm a lawyer. I've downloaded that thing and used it. I found it very good and helpful. So I highly recommend people download that and study it. But even though they're looking at it on their words on a paper, but it's very easy, or there's a lot of myths and misconceptions surrounding the laws of self-defense. In your practice and your experience, I mean, what are some of those things that people get wrong, even though they might be able to recite verbatim those elements back to you that you just went over?
Yeah, I mean, one of the most common questions I get is which of the elements do people screw up the most? and the truth is, it's all of them. It's all of them. We need to be very careful, especially when we're talking about deadly force self-defense, because the consequences of getting it wrong are tremendous. I mean, and of course, there's 2 fights, right? There's the physical fight, and that has to be the priority. If you don't win the physical fight, the rest of this stuff doesn't really matter. But you don't want to win the physical fight in such a way that you just end up spending the rest of your life in a cage with unpleasant people. And unfortunately, people, we think of ourselves as rational and critical thinkers and all this kind of stuff, but that's a facade civilization puts on people.
Mm.
We're emotional creatures. Nobody likes to be insulted or have their wife insulted or their kids insulted, be treated with disrespect, be threatened in any way. And people's emotions get spun up and they
Mm.
start making bad decisions. We need to be making emotionless, egoless decisions in self-defense, especially if we're considering deploying deadly force in self-defense. So how do people get in trouble on self-defense on any of these elements? Well, they become an aggressor in the fight. They become a
Mm.
mutual combatant. They agree to physical combat. Or they get scared of something that's threatening, but it's not yet an imminent threat, and they use
Mm.
force too soon. Or they
Yeah.
use force too late. Something was a threat, but now it no longer is, and that's when they decide they're going to fire that shot.
Mhm.
That's not an imminent threat any longer, so it's not a lawful shot to fire. They get a gun. Proportionality is a big one. They go out and get a gun. They get a concealed carry permit. They're walking around in public with that gun, which is great. That's what I do too. But it's the only defensive tool they have. And then they get
Mm.
scared by something and they go straight to that gun. But what they're being scared by was not a deadly force threat. It was maybe a shove. Well,
Mm.
a shove is not deadly force, and you can't go to the gun to defend yourself against a shove. But people get scared, and they do. That's how we get these aggravated assault with deadly weapons charges.
Mhm.
On the element of avoidance, they could simply have walked away from the
Mm.
confrontation, and they chose not to do that. And,
Mm.
frankly, anytime you have that, the best way for good guys like us to win fights is to not have to fight in the first place. I
Mm.
don't care if you're in a stand your ground state. If you have the option to walk away consistent with your own safety and the safety of people you have a duty to protect, you're a fool if you don't do that. Why are you getting
Mhm.
into fights you don't need to be getting into?
Yeah.
And then reasonableness, people just panic. They get scared, and we don't make better decisions under stress. We tend to make worse decisions under stress, and people don't mentally prepare themselves for violent encounters. Very few of us are routinely subject to violent encounters. We forget how stressful it is when it happens and how difficult it becomes to make sound decisions. So people really need to condition themselves mentally for the stress of confrontation. And when they don't do that, well, then they end up making bad decisions.
Well, what would you suggest as far as ways that people can, that mental component, preparing themselves, so that they don't run afoul of some of the scenarios you just mentioned?
I mean, there's a lot of levels for this, right? Some of these are kind of tactical considerations, like just running the gun, for example.
Mhm.
When you first get a gun and you first start to shoot, we all start in the same place, right? We all start at zero. Just manipulating the gun can be intimidating. There's
Mm.
safeties, or there's things that have to be done, or there's a 4-step process to present it from the holster and so forth. I urge people to get over any friction there by simply engaging in competitive shooting.
Mm.
You do a couple years of competitive shooting, and your gun handling will be amazing
Sure.
compared to the general public. So that's one point of friction that people can overcome. In terms of more mental preparation, when we talk about getting good with a handgun, for example, we often talk about dry fire, right? You're not at the range, you're not turning
Mhm.
money into noise, you're just in your basement or whatever in a safe environment, going through the motions, pressing the trigger without discharging the gun, and you can dry fire in a mental sense for these law of self-defense issues too. I encourage people. I mean, once you mentioned my book, which I appreciate. And by the way, we give the book away for free. So people can get this book at lawofselfdefense.com/free book. But I encourage people to get the book, to download that elements cheat sheet I just described. And then when they hear about a use of force event in the news, on the internet, in the
Mm.
paper, think about, well, where are those elements in this scenario? What could this person have done to make themselves harder to convict by having a more robust self-defense narrative? What
Mm.
mistakes did they make that I would want to avoid? And of course, we can't predict every facet of a violent encounter that might come to us, but they're not that different. I mean, they tend to fall into generalized categories, generalized buckets. And I think people should do this kind of mental dry firing from an informed perspective, knowing what the
Mhm.
legal principles are, and apply it to these use of force events they read about in the news, because it's like airline pilots, right? We don't expect pilots to learn from their own crashes, right? That would be a very inefficient way to learn.
Yeah.
We expect airline pilots to learn from other pilots' crashes. Well, we should expect to train ourselves in use of force, cognitive thinking, maintaining our mental bandwidth so we can make good decisions under stress by looking at other people's use of force events. And while it's true that virtually all media reports of a use of force event are going to be wrong, they get the facts wrong, they get the law
Mhm.
wrong, it's still a good training framework for us to use
Hmm.
for this kind of mental dry fire.
Yeah, yeah, I agree. This is a area that you can not only just, it's not enough just to read it and see the words on the page, but really think through the material, engage with it, and develop, your in a sense your own rules of engagements, right? That conform with the law. I seem to come across.
Right.
I'm not going to say that it's not everybody out there, but I've heard it enough that I'll bring it up and it's something we could talk about. But everybody in life, they want a bright line rule. They want an easy button, and so they kind of refer back to these mantras. And I can't tell you how many times I've heard where we're discussing something in class and someone's like, well, if you shoot the guy outside your door, you
Mm.
better drag him inside, things like that. Or better judged by 9 than carried by 12, or whatever the saying is. I mean, have you come across those types of mantras before?
Yeah, of course. And normally these things are the refuge of people who are scared. It's
Mm,
like thinking about life insurance, right? They don't want to think about bad outcome events. And they find it comforting to pretend that they know what they're going to do and pretend that that's going to be deemed to be lawful by society. There really aren't any bright line
mm,
self-defense scenarios. It's really a continuum. Just like the physical fight is a continuum, right? I mean, if we're prudent, we train for the physical fight, right? Maybe
mhm,
it's guns, maybe it's jujitsu, whatever it is. We get tools, we get training in those tools, and we practice the use of those tools so we're proficient in our
mhm,
ability to defend ourselves and our family from criminal predation. But I don't care how good you are with a gun or a knife or your hands, the risk of losing the physical fight is never zero. There's always
mm,
some risk of losing the physical. It might just not be your day.
yeah,
And that's true of the legal fight too. I urge people to get my book and learn what we teach so they can reduce the risk of losing the legal fight to as close to zero as possible. But it's never zero. I mean, you have experience in this. I know every client I deal with, I have to tell them, especially if there's a plea deal on the table, which they don't want to take because they acted in lawful self-defense.
right,
They're convinced. Um, if I have to put you in front of a jury, there may be a 50% chance you get convicted, no matter how innocent you actually are. So
mhm,
the risks of the legal fight are real. Now, can you mitigate those risks by learning what to do, learning where the legal boundaries are, planning out your self-defense strategies ahead of time so you know they're inherently legally sound? Yeah, you can make yourself really hard to convict if you do it right, but the risk is never zero.
mm,
And that's why I tell people, don't get into fights you don't need to get into, because you could be the most innocent person in the world, do everything tactically right, do everything legally right, and still find yourself convicted. And so I always urge people to, when they're thinking about the circumstances under which they'd be prepared to use a gun, for example, be aware that you could get convicted no matter how right you do everything. And I tell people, you need to think to yourself, if you're sentenced to 20 years in prison because they called that murder and got you convicted on the murder charge, on the last day of that 20th year, would you still be able to tell yourself that pressing that trigger was the right thing to do? And you would
mm,
do it again without hesitation, because that is the price you might pay
mm,
for pressing the trigger. And there are
yeah,
things that are worth 20 years in prison. I'd rather be alive in prison than dead outside of prison.
mm,
I'd rather be in prison than have my wife killed or maimed, or my children
mm,
killed or maimed, my parents. Uh, but but that's about the limit on my list. I mean, there's not a lot of things I'm willing to go to prison over.
yeah. No, I really like how you bring that up, that it really is about risk mitigation. I can't imagine a reasonable person, who's arming themselves and training on a regular basis would say, well, just because I'm armed now, I have a 100% chance in prevailing against any engagement that I might find myself in. And yet there does seem to be that disconnect when it comes to the legal side of it, that, hey, I was in the right, I did everything right. And it's almost like sometimes people get upset with me, when I start talking about the legal aspect and how that is very much of a fight, and you can do everything right and still not prevail,
Right.
that it really does come to, like you said, understanding the law, being able to articulate your actions and how they conform within the law. And even then, it's not 100% deal, right? I mean, you could still be convicted.
You could. I mean, the good news is, now that I've horrified everybody, and Often I talk with people or I give talks and people come up to me afterwards and say, oh my God, I'm so terrified now about the
Right.
legal stuff that I'm just not going to carry a gun anymore, which is not at all my intent. As I said
Ye
earlier, I carry a gun for personal protection. I do every day. I have my entire adult life. The good news is that making yourself hard to convict, making yourself look like an unattractive target for prosecution, um, can really mitigate these risks because
Mhm.
prosecutors generally do not like to take cases to trial unless they have a high prospect for success in getting a conviction. Most prosecutors, when they go to trial, they have conviction rates in excess of 90%, 95%. I think the federal prosecutors, it's 98%. And
Mhm.
it's not just because they're good lawyers, although many of them are great lawyers. It's because they get to pick the cases they take to trial, right? If your favorite sports team got to pick the other teams that played, it would have a winning record of 90% too. Um,
Mhm.
and they pick the ones that they believe they have a good prospect of getting a conviction on. And if you can make yourself look like a hard case to get a conviction on, well, then you're deprioritized on that prosecutor's desk. Sure, he has the discretion to take any case to trial if he wants to, but he will not want to if you look hard to convict. And
Mhm.
that's the plan.
Anecdotally, I could totally verify what you just said, having been a prosecutor for 6 years. I mean, if you're running a docket with 200 cases, there is just not, and sometimes this would cause friction with my police friends, right? When they bring a case and that they think, no, we got to go forward on this, we got to go forward on this. And when you're running 200 cases, preparing for a trial is a big deal. A lot of late nights, a lot of weekends. I work tons of weekends on government pay, in
Right.
preparing for these trials because as a prosecutor, you only get one shot, right? I mean,
Yep.
at it pretty much. And so, yeah. Now there were some cases where I had a I forget what the ethical rules on it, was, but I could in good faith go forward. And because of some considerations, you had to. Oftentimes those would be homicide cases and things like that. And, where I could make a good faith argument, but at the same time, it wasn't like I went in there just thinking, oh, yeah, man, this is going to be a slam dunk. But for the most part, yeah, I would be hard pressed to just, you know, for shits and giggles, cobbled together a case that I knew I was going to lose. And really and frankly, from an ethical standpoint, I was ethically bound not to go forward on cases that I didn't have a good faith belief, that I could, I don't want to say prevail on, but you know what I'm saying.
Yeah, and
But
I would wager if you're like every other prosecutor I've ever met, you always had more cases on your desk than you could possibly bring to trial.
sure,
So you
sure.
have to make these choices about which ones you want to bring to trial and which
Hmm.
ones you don't, and that provides an opportunity for the lawful defender to again be the lowest priority
Right.
folder on that prosecutor's desk. And
Yeah.
then your prospects are those are the cases that get dismissed or at least put into a deferment program where if you keep your nose clean for a number of months, the charges go away, which is not hard for normal law abiding people to do. Criminals slip up on that stuff all the time.
Yeah.
But if you're a normal law abiding person and you get a diversion program offer, that's a pretty sweet deal. I would
Hmm.
consider taking that and just make sure you don't get in trouble for a while.
Yeah. Right. Right. Let's shift on to a big key word within the law, and that is reasonableness. That's one that's again, it's very easy to read. It's very easy to think that you understand, but the way that that gets played out could be very different based on your jurisdiction, based on your jury pool, right? That's those when I was first out of law school and first running jury trials, that was something that was very hard for me to get my head wrapped around. Is like on paper, I could have this case that looked like a total winner, but you take it upstairs and, you know, your jury pool, you could be different. I believe that like I could have a case on Monday to one jury pool and win and present that same case to a different set of juries and may have a different outcome just based on the jury pool. So that's where reasonableness is such a tricky thing. Can you kind of unpack that a little bit about what is reasonable force?
Yeah, it's very it's a very dangerous element. And
Yeah.
if people look at their own state self-defense law, like just look at your state self-defense statute, you'll find reasonableness everywhere, all over that, sometimes used more than once in a single sentence. I mean, that's how
Mm,
much weight and importance the law of self-defense places on this element of reasonableness. And there are elements of self-defense that can be kind of binary, right? So whether or not you try to retreat from a fight, I mean, there may be physical evidence of you backing away from a fight. It's very binary. Or if the fight involved a gun, clearly it was a deadly force fight in terms of proportionality. But reasonableness is never like that, because people have to keep in mind what controls your legal fate is not what you thought was reasonable. What controls your legal fate is what other people think was reasonable. The police, the prosecutor, the judge, the jury. You could think it was reasonable all day long, but if they disagree, it's their determination that controls whether or not you go to prison. And they're making that determination in perfect safety with perfect 20/20 hindsight, not in the midst of a fight or being attacked or wondering if they're going to survive. And so it becomes a very vulnerable element for a prosecutor to attack because it's so subjective and so soft.
Yeah. Yeah. And I mean, that could change. It could change too, depending on what part of the country you're in, right? Like you could try a case down in Texas, and that there might be a case, the prosecutor may not even bring it forward in Texas, but you go up to, not to pick on California or someplace like that, right? You could take it to San Francisco or something, and you could find a very different attitude with the prosecutors there, right?
I mean, just look at, so as we're recording this right now, this week, I'm not sure when you're going to air this, but we're having the Daniel Penny trial in New York City. Daniel Penny was the Marine who choked the violent, crazy person on the New York subway who ended up dying. And now Daniel Penny is on trial for second-degree manslaughter and criminally negligent homicide and may well get convicted. Who knows? But if you read the New York papers about the case, you read like letters to the editor. There are people writing letters to the editor calling this a murder. Saying, well, why didn't he just give the crazy guy some money so the crazy guy could buy some food and feed himself? How heartless was he? It's like, is that really what you're going to be thinking about when someone's threatening to kill everyone in the subway car? But all these people could have been selected for Daniel Penny's jury, and they would be coming to the jury with that kind of mental framework. That people don't like bad outcome cases, right? Now, I expect if you ask Daniel Penny, he would tell you the last thing in the world he wanted was for Jordan Neely to die in that subway. But someone did die. Jordan Neely did die. So we have a bad outcome, and now people want, quote unquote, justice for the bad outcome. If there was a bad outcome, somebody has to be held accountable. And it can be very difficult for them to wrap their minds around the fact that, listen, bad outcome cases happen all the time, and they're not necessarily crimes.
Yeah. So I'm glad you bring that up. So we talked about the laws of self-defense, and we're kind of focused on protecting yourself. But what about coming to the aid of other people? How does the law apply to you in terms of you're not the one in danger, but you see someone else in danger and you're trying to protect them? How does that play out?
Yeah, I really put the defense of others scenarios into three buckets. So, and the most hazardous is coming to the defense of a stranger, right? So you turn a corner, you see a fight happening, someone appears to be losing, you decide you're going to come to their defense. And it's dangerous for a couple of reasons. One is you don't really know what's going on, right? You're entering the midst of the fight. You don't really know who the bad actors might be. Maybe the person you're coming to the defense of was the person who started the fight. There's really no way for you to know. Maybe what looks like a fight is actually a couple of undercover cops making a lawful arrest of somebody. I mean, you just don't know. Maybe the person you rescued was actually getting beaten by somebody. But then when the cops arrive, it turns out they were getting beaten by their baby daddy or whatever, and they don't want that baby daddy to go to prison. So they turn around and say, you were the problem. You started the fight. You have no control over what and if people think that's unimaginable, just ask any officer who's ever responded to a domestic call. I mean, this kind of stuff happens all the time. So there's a lot of danger in coming to the defense of strangers. And I don't tell people what to do. So I want to make clear, I'm not telling anyone not to come to the defense of strangers. If that's what you want to do, that's fine with me. I just urge you to make an informed decision when you're doing that and understand the risks that you're incurring. Because the situation is inherently ambiguous. You have imperfect information. And again, what are the stakes? Even if you draw your gun and never fire a shot, you could be looking at a 20-year felony, aggravated assault with a deadly weapon. Those are the stakes we're talking about. By the way, if it turns out to be an undercover arrest going on, and you're pointing your gun at cops now, what do cops do when people point guns at them? They tend to point guns back, right? So it's physically dangerous as well as legally dangerous. Now, those risks get tremendously mitigated if the person you're defending is not a stranger, if they're somebody you know, if they're a family member. if they're somebody you work with, if they're a good friend, because one, you know something of their character. You know how likely it is for them to have started the fight, for example, and they have an investment in you, a relationship investment. They're unlikely to lie to get you into legal trouble. So I think that's a separate bucket. Defending people you have a duty to protect their friends, their colleagues, their family. That greatly mitigates the stranger defense risk. And then there's a third bucket where you are defending strangers, but there's no ambiguity about what's happening. And that's really an active shooter type of situation.
Mm-hmm.
So some dude's walking around a shopping mall with a rifle shooting people, or walking around a school shooting kids. There's no ambiguity about who the bad guy is there.
Mm-hmm.
And the prospects of getting in legal trouble if you intervene to try to stop that active shooter is about as close to zero as you could possibly
Mm-hmm.
imagine. Now, having said that, of course, the physical risks are substantial, right? Some guy's walking around with a rifle, and you're showing up with your little subcompact SIG 365 9mm pistol. I mean, I guess you do what you have to do, but if I had the choice, I would switch weapons with that guy.
Yeah.
So the risks of, I think about it, and I've never been in the military. I've never been a cop. I don't consider myself particularly brave. I'd like to think if I had a shot to take, I would take the shot to stop that kind of event. But I would be doing that with the expectation that I was unlikely to survive the event myself.
Mm-hmm. Mm-hmm. Yeah. So getting back then to the 5 elements we discussed. So, to analyze whether or not your actions are justified, is it true that like all those 5 elements of innocence, eminence, reasonableness, proportionality, all those things that you talked about, they have to apply to the victim that you're trying to intervene to save, correct? For it to be for that privilege of self-defense or I'm losing the word, but for that to apply to you,
Sure.
to transfer to you, right?
Yeah, so generally you can use force in defense of another person to the same extent that person would have been privileged to use force themselves.
Mm-hmm.
So you see someone being attacked with deadly force, they don't have a gun. They can't defend themselves against a deadly force attack, but they would be privileged to use a gun, we're assuming, if they had one. Well, then you're privileged to use a gun on their behalf.
Yeah.
So you're allowed to do basically what they would be allowed to do in their own defense.
Right. And then again, getting back to your point, that's why it's so tricky sometimes, because it's very difficult always when you come up onto a situation to assess whether or not all of those elements are met within that third party that you're trying to, on whose behalf you're trying to intervene on, because that has to be there. Like you said, all of those elements have to be there for you to raise the self-defense.
Right. So if you're attacked yourself, right, you know that you were attacked. You know you're not the initial aggressor in the fight. So you know you have that element of innocence, for example. But if you turn a corner and see a fight going on, you don't know who started that fight. You don't know if the person you're defending might have lost the element of innocence, might themselves not have a legal privilege of self-defense, in which case, what's your legal privilege to use force on their behalf?
Yeah. I could
just
tell
can't
you just,
know.
Yeah, you can't. Yeah, and that's why it's so difficult. Again, not telling people what to do, but those are things that you have to think about. I can tell you just, from my own time, I had cases. I actually saw some video footage of this. It was from a security cam of a guy that was beating a woman, right? And turned out to be his girlfriend or whatever. And this guy intervenes and starts trying to protect this woman. And the guy ends up, the guy that was doing the beating, the boyfriend, okay, he starts fighting the Good Samaritan, and the woman jumps on the back of the Good Samaritan and now it's a 2-to-1. Like you just don't know what people are doing and the dynamics involved. And it boggles the mind why that would happen.
And what is she going to tell the police when the police show up? Is she going to tell the police that you were rescuing her?
Oh, yeah.
Right? Or is she going to tell the police that you were the bad actor? They were just minding their business when you stepped in and caused the trouble.
And I've had that too, when law enforcement would show up to domestic disturbance, right? And, break them up and arrest the guy. He goes to jail, and the victim is calling our office saying, basically exact opposite of what the officer said, and saying, oh, this was misunderstanding. The officer came in, he was heavy-handed, he did this, and just fabricating, whole cloth, just the scenario and turning it up on its head. I mean, I've seen that a lot. And so,
and it's important to keep in mind that the people who are deciding your legal fate, let's just focus on the jury here. they don't know what happened
Yeah.
in any absolute sense, right? They weren't there. In fact, if they walked into jury selection with any preconceptions, they wouldn't be seated on the jury, right? They're literally supposed to be a blank sheet of paper when they're seated on the jury. So they have no idea what actually happened. They're going to arrive at a verdict based on storytelling. They're going to hear a story of guilt from the prosecution, and they're going to hear a story of innocence from the defense. They'll be told explicitly by the judge, you must arrive at your verdict based solely on the evidence and legal arguments you hear in this courtroom, which really just means those two competing stories.
Yeah.
So there is no absolute truth, and the system's not designed for absolute truth because we know it's impossible. People are effectively making their best guess. And if they guess the wrong way, you're going to prison for 20 years.
Yeah, it's a good point. It's a good point. You did let me see, I had a couple other things that I don't want to jump ahead of myself here, but while we're on it, you did an episode on your podcast, at the date of this recording, we just had that horrible natural disaster that happened out in North Carolina. And there's a lot of folks I know that listen to our podcast that are prepared, that they have stockpiles of whether it be ammunition, food, or things like that. But in a natural disaster, I mean, normally, right, the rule of thumb is you don't use deadly force, to resolve a non-deadly situation, i.e. protecting property, right?
Yeah, personal
Generally.
property.
Yeah.
So
yeah.
we should really put property into two buckets, right? There's personal property, which is just items, right? Just stuff like a phone, my phone on the camera. This mug is personal property. Generally speaking, you can only use non-deadly force in defense of personal property, and only sometimes. There are circumstances in which you can't even use non-deadly force in defense of personal property. So when it comes to using force in defense of stuff, I generally tell people, I mean, I'm not inclined to use force in defense of my personal stuff. A house is different. So there is highly defensible property, different than personal property. It always includes your home, for sure. Often it includes a place of business, an occupied vehicle. And there are some special provisions that can exist for the use of force in defense of highly defensible property. But what's really happening there is you're not really defending the property. The property is serving as a surrogate for the people inside the property. Your castle, you're inside your castle, you're inside your occupied vehicle, for example. But normally when it comes to like the barbecue in your backyard, if someone just picks it up and starts walking away with it, you're not allowed to shoot that guy for taking your barbecue. The only exception is Texas. Texas has a provision for deadly force in defense of personal property. I would not encourage people to try to take advantage of that. It does work. They do apply it. But there are hoops that have to be jumped through. There's conditions like things have to be happening at certain times a day. And if you miss any of the hoops, you lose the justification. And then if you shot someone and they died, you're just looking at a murder conviction. But generally speaking, if it's just personal property, only non-deadly force. What came up in the natural disaster scenario was in that circumstance, it's possible that you have some personal property that is essential to your survival. And if that personal property is taken from you, it could mean your demise. Maybe not instantly, but before help could get you. So if you imagine, for example, someone who's a diabetic, they have insulin, they need to take the insulin every day, and someone decides to steal the mini fridge they keep that insulin in. Well, if it's a natural disaster, you may not be able to access insulin elsewhere for a week or 10 days. You'll be dead if that insulin is taken. So there, I would argue, you're actually looking at not a property crime per se, but a deadly force attack. It's just that the effects of the deadly force attack are just drawn out until you suffer whatever the loss of insulin does to you. But if they take that insulin, you will die, just not immediately, but inevitably you will die. And there, I would argue, there's a good argument can be made for the use of deadly force in defense of that in the moment, and that could theoretically apply to food, clean water, whatever would be the limiting constraint that would put you or your family at substantially greater risk of not surviving the disaster.
So I like your phrasing on this, because you're saying you could make the argument, like if this happened and you took this action. I mean, that's the key thing I want people to come away with when you come to applying the law. Is you're using facts that you can articulate that were on the ground, that you acted with reasonableness, but at the end of the day, you're making the argument and then that argument, whether or not it holds water, is going to be up to the jury, and
Right.
who knows who those people are and if they see it the same way you do. But at least
Yep.
you can make the argument, right? Versus they took my tennis racket and, hey man, I'm a tennis pro. That's my livelihood. You know what I'm saying? It's just, that's what we're talking about in terms of reasonableness.
Well, it happens a lot, like with tradesmen. Their truck gets stolen with all their
Mm.
tools in it. That's how they pay their mortgage.
Mm.
And I understand that why they would want to use deadly force to defend that property, and I'm sympathetic. And if the law allowed for that, okay, I would have no problem with that. But the law doesn't, and that's where
Yeah.
people get into trouble.
Yeah. So, since we've gone through 2020 and all the crazy things that happen with regarding to health and all that stuff, I think everybody knows what I'm talking about. But we know that gun ownership has skyrocketed in the last year. A lot of folks are getting armed. Hopefully, those folks are also getting trained and everything. But as far as what do you think are, as far as legal considerations, are some of the most overlooked things by concealed carry holders?
I think the biggest thing people need to be worried about, where I see people get in the most trouble, is that they think the gun is a universal answer to any confrontation problem they may have. And it's just not. It's just not. The gun is only an appropriate response to a deadly force threat. And if you look at the Department of Justice crime statistics, you're 5 times more likely to be the victim of a non-deadly force threat than a deadly force threat. So the gun is the appropriate defensive response in maybe 20% of these criminal confrontations. For the other 80%, you need a non-deadly force option. You need pepper spray. You need, bare hand skills. You need something other than going to the gun. But people don't. They get the gun, they carry it around, they stick it in their purse, whatever, and they think, all right, now I'm all set for a confrontation. But if you go to that gun under circumstances that don't justify the privilege to use deadly defensive force, you're running a lot of risk. Now, a lot of people get away with it because whether or not you're arrested and charged and prosecuted and convicted, those are decisions made by other people downstream. And in a lot of cases, the authorities just choose to use their discretion not to charge you, not to prosecute you, not to convict you. And people read about those events and they conclude from that absence of a charge or prosecution or conviction, well, that must have been lawful what that person did. But that's not necessarily the case at all. It's often just an exercise of discretion by people in authority, not to make you suffer the legal consequences for what you did. If they wanted to use their discretion differently for a variety of reasons, maybe it's politically motivated, maybe there's some kind of racial disparity in the confrontation that makes the case attractive to them. Maybe they're bored that week and they don't have a lot of work to do, so they decide, well, we'll hand this one to the new guy we hired in the prosecutor's office, give him a little trial time, see how it goes. So they're not thinking of you as a human being. You're just like a Lego character in their world. And you're incurring those risks, even if you've read news reports about people who did the same thing and didn't suffer legal consequences. So we have to be concerned not with what the criminal justice system might do to us if it's feeling kindly disposed to us. We have to, just like in the physical fight, we have to be prepared for what the criminal justice system can do to us if it wants to throw the book and stay so far within the legal boundaries that, again, we make ourselves an unattractive target for prosecution.
Yeah. So let's go to another one that can be kind of controversial at times, and that is, if you do get involved into an incident and the police arrive, right? What do you do? What do you say? And before I pitch that question to you, I'll just tell you I've kind of had an evolution in my thinking on this. When I first got out of the prosecutor's office, in my mind, we were the good guys. If I didn't have I would drop so many cases. When I evaluated, looked at the evidence, either I would drop it because I didn't think the evidence was there. Other times I would look at the evidence and say, yeah, I think this person was in the right. I don't want to go forward I think this citizen was just trying to do the right thing and did the best that they could. And I don't feel comfortable going through this. And so because of that, and all of my friends were cops, the people I hung out with cops, and they've been so demonized in the media, but these are real people that have families. And these guys, of course, I know there's bad apples in any profession, but on the whole, the police officers I know really do want to protect their communities. They really do want to go after bad guys and not waste their time, stringing up good guys. And so, and lastly, I would also say that sometimes there were cases that were resolved because the victim, right, that took that action did cooperate with the police. They did tell their side of the story there during the investigation. And I would look at that and I would be like, yeah, I'm glad I had that, because if I didn't have a statement from them, all I would have to go on is just the body on the scene, the weapon that's there in their hand, and so having their side of the story to balance out with the other evidence helped me make a decision. Now, there's a flip side to that getting and saying things to the police, even if you're in the right, can get you into trouble. So I would assume you, as a defensive attorney, well, I'll just let you answer that. What do you advise people to say or not say when the police arrive?
So I really put this into kind of three buckets. Again, I like my bucket analogies, but on one end of the continuum, you have just say everything, just blather away, just give a complete, comprehensive explanation of what happened to the police. That's a bad plan, because you're the more you say, the more building blocks you're providing to a prosecutor to build a narrative of guilt. You don't know what words come out of your mouth that can be used to harm you, can be used against you. You just don't know. But the more you say, the more material you're giving to the prosecutor to build the case against you. So blathering, bad plan. Absolutely do not do that. The other end of the continuum is literally say nothing. And you hear this a lot. Never talk to the police. Never say anything. And I just, if you're a criminal, you should definitely not be talking to the police. Okay, if you're an actual criminal, only bad things will happen to you from talking to the police. But if you're a normal law-abiding person and you've acted in something that resembles lawful self-defense, I think this advice to literally say nothing just it doesn't make sense to me. So, for example, are you not, you've shot someone who tried to kill you. Are you not going to call 911? If you call 911, I can tell you what's not going to happen. Ring, 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 911, what's your emergency? And you're literally not going to say anything? I mean, that doesn't make any sense. The only reason to call 911 is to have resources sent someplace, right? Send police, send an ambulance. And so now you're talking to 911. And if you're talking to 911, guess who you're talking to? You are talking to the police. So I think this advice to simply say nothing, or say nothing except I want my lawyer. I mean, 911, what's your emergency? I want my lawyer. I mean, that's not how that call is going to go. That doesn't make any sense. So I think invariably you're going to be saying things. So I think it's more prudent to think about what it is you're prepared to say. And again, I don't tell people what to do. If you want to just be totally mute when the cops show up, that's fine with me. By the way, that can potentially be used against you in court. I would discourage anyone from just blathering away, but I think there's a kind of a more professional approach where people can think ahead of time, what am I prepared to say? And say only those specific things, and then shut up, or assert your rights, I should say. So, for example, your name. You may as well tell them your name. Everyone's going to know your name. That's not saying secret, right? If you shot someone, you need to justify that shooting, or it's a crime. So you may as well tell them, I had to defend myself. That's going to happen too. You'll be raising the legal defense of self-defense. Then, not on 911, because 911's not present, but that's another thing. There's different police interactions, right? There's the 911 call, there's the first responders, and then there's the detectives. When the first responders get there, you may want to consider pointing out exculpatory evidence and witnesses, right? If someone came at you with a knife and you shot him in self-defense, you need that knife recovered in evidence. If that knife is not in evidence, it doesn't exist for legal purposes. Right. And that's why you shot the guy. That's your justification for shooting him. So if that knife slid under a car when you shot that dude, you need the cops to find that knife, to secure that knife in evidence. I don't think your lawyer is going to think you're a genius because you kept quiet while the knife disappeared. That's not going to be helpful for your case. So I would point out to the officers on the scene, hey, there's exculpatory evidence consistent with self-defense. There are witnesses who saw what happened, because by the time there's 5 patrol cars with lights on, there may be 100 people standing around to see what's going on. The cops will never find the actual witnesses. So you want their statements. In good guy cases of self-defense, generally more evidence is good for us. We want
Right.
more evidence. We tend to get into trouble when our claim of self-defense looks speculative or fabricated. So generally, you want the evidence secured. Now, once you've secured the evidence, I generally tell people at that point, assert your rights. Unequivocally, it has to be unequivocal. I assert my right to silence. I assert my right to counsel. If you say, I don't know if I should say anything more, that's not an assertion of your right to silence. And if you say, maybe I should have a lawyer here, that's not an assertion of your right to counsel. You have to unequivocally assert your rights. After that point, they can't use your silence against you in court. And then, of course, that's the responding officers. Then the detectives show up. And you should not say a damn thing to the detectives. I mean, there's no upside from you talking to them. Now, they may need to be spoken to, right? I mean, you mentioned often you dismiss charges because you heard the defendant side of the story and it made sense to you and charges didn't seem appropriate. But if the detectives need to be spoken to, your lawyer does that. You talk to your lawyer talks to the detectives. We are prepared to present blah, blah, blah. This is the narrative of innocence, the narrative of self-defense, because what your lawyer tells the detectives cannot be used against you in court. What you tell the detectives can be. So you want that filter between you and the detectives. Now, having said all that, for many years, I taught maybe 40 day-long law self-defense classes a year. Almost every week I was traveling. And as part of that full day class about the law of self-defense, I would bring a shooting simulator with me in a big Pelican case, and they would project an image of a self-defense encounter on a screen, and the student would have a fake pistol, an infrared firing pistol, and they had to look at this video of a possible confrontation, and they had to solve the problem. And that might involve, pretend firing a shot or whatever the case may be, or not. It was up to them. And then after the video was over and after they had solved the problem however they thought best, they had to turn their back to the screen and tell the rest of the class what they saw, what they did, and why they did it. What was their legal rationale? And this is a completely safe environment. I want to make clear. They're looking at a video. It's like a video game, right? There's no way for them to actually get hurt. But the stress these people experienced going through the shooting simulator was unbelievable. I mean, their breathing became more rapid. Their hands would shake. They couldn't remember what they saw. The video is only 30 seconds, 45 seconds. They couldn't remember what they saw. And if I suggested things that weren't in the video, like what color was the guy's hat, they'd come up with a color, even though there was no hat. And it's because the way our brain captures and stores and recalls information under even this minimal amount of stress is completely different than our normal experience. And, if you interview people after a violent confrontation, and it's even police who are trained for this, an hour after and 6 hours after and 20 hours after, you get different versions of the story from them because the brain chemistry is still settling. That's why police are often allowed to not make a formal statement for 24 or 48 hours or whatever, because we understand this dynamic, and police get the benefit of that. But often, civilians don't know this, and the cops show up and they want to explain what happened, and so they tell a story about what happened, and they believe the story's true. They're not lying in the sense that they believe they're providing correct information, but their brain is broken. Their brain is not capable of providing the accurate information. And if they make another statement the next day, it's going to be different. And then it looks like, well, which time were you lying, sir? Was it then or was it now?
Yeah.
So anyway, running people through that simulator, it really led to an evolution in my thinking. When I first started teaching, hey, think about saying these specific things, I was pretty confident in that approach. But after seeing people experience that level of stress, I get more nervous about it. And I have to caution people, listen, there's a real risk that you won't be able to do this. You won't be able to say the specific things and then stop, that you'll start blathering. And if you start blathering, you're likely to blather your way right into prison. So I don't know you. I don't know how you respond to stress. We all respond to stress differently. If you feel that you can limit yourself to this kind of professional form of interacting with the police, say very specific things and no more, that's what I expect to do if the worst should ever happen. But if there's a real risk of you starting to blather because of the stress, then you just have to keep your mouth shut.
Yeah, 100%. I cannot emphasize that enough. All the law enforcement training, I've done a lot of it over the country. And this one thing that keeps coming up is how, and even if it wasn't part of the class, I would always poll them because I'm doing research off the cuff is, what is your policy when you get involved in a critical incident? And 99% of the time, right? There's an administrative investigation that's done internally within the police department or sheriff's department. And that did seem to be the rule of thumb, that before they took a statement from the officer that was involved in the shooting, they would wait at least 24 hours, a lot of time 48 hours, because they understood that when you get involved into a high intense situation, the parasympathetic nervous system kicks off. Blood is being diverted away from and energy is being diverted away from the rational part of the brain to that reptilian brain, the fight or flight things. And so, yeah, your ability to recall and articulate the things that were happening on the ground at that time is just diminished. And it's there in your memory banks, but it's just not accessible then until you've had a little time to quote unquote sleep on it, so to say. And so if you do make a statement, you're stuck with that because it's recorded, it's evidence. And then if you want to come back and try to redact it or revise it, that's a non-starter. I mean, that, and if anything, that does, although it's genuine on your part, it makes you look guilty, right? Or it can.
Yeah, and it can, right? I mean, listen, as you well know, if a prosecutor is taking you to trial, it's because he wants the conviction, right? If he didn't want the conviction, he wouldn't be taking you to trial. Yeah. So he's going to use whatever building blocks he has to build that narrative of guilt to achieve that conviction. And if he has inconsistent statements from you, why would he not use the inconsistent statements to suggest you're not being truthful? And if the jury believes you're not being truthful, in a self-defense case, your credibility is everything. If they can't believe you, how are they supposed to think it's self-defense?
Yeah, exactly. That's a good point. Andrew, man, I really enjoyed our talk. I hope maybe you'll consider coming back on, because I think there's some things that we covered here that could be its own episode for sure. But before we go, are there any projects that you want to tell us about that you're working on, or anything that you'd want the audience to know that you're up to?
Yeah, actually, we do have a free seminar coming up in, I think, December 7th, maybe, Pearl Harbor Day.
Wow.
I could be wrong about the date, but I'll share the URL. It's 100% free. It's about an hour and a half seminar talking about self-defense law, many of the types of things we talked about today. And we just provide it for free. And people can find that at lawofselfdefense.com/hard-to-convict. Hard to convict, because that's the purpose of the webinar. Again, it's free. The only thing is we do limit the number of seats because it is live. And we have Q&A, and I have to constrain the number of people so we can have effective Q&A. So if people are interested in that, I would encourage them to grab a seat sooner rather than later. But again, it doesn't cost anything. That's lawofselfdefense.com/hard-to-convict.
And then as far as the way that people can follow what you're doing, is there any particular link apart from that one that you'd like to include in the show notes that I can stick in there?
I think if people download that 5 Elements of Self-Defense Law cheat sheet, or if they get our free book at lawofselfdefense.com/free book, we do like internet content just about every day of the week, every business day of the week. And then we send out emails to notify people that, a new show has gone out. And that's probably the best way for people to get regular exposure to the kind of content and analysis that we do here at Law of Self-Defense.
Awesome. Well, Andrew Branca from Law of Self-Defense, he's doing good work, putting out really good info. I follow you. I watch your stuff. I've really benefited, and I used to do this for a living. So if I get a benefit, I can imagine someone who hasn't spent any time in that world would really, really help fortify their own position and well-being, and following your content as well. So any last words before we sign off?
No, I just always caution people. It's how I always close my own shows. I just remind everybody that if you carry a gun so that you're hard to kill, that's what I do. I carry a gun, so I'm hard to kill, so my family is hard to kill. Then I would suggest you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well.
Awesome. Well, I'm Mark from Pearl Snap Tactical Podcast. Thanks for being with us, and just reminding you to stay sharp and keep it Pearl Snap. Thanks, guys.